The 25 million rand Nolane Investments criminal trial, the first state capture case brought by the investigative directorate to reach trial stage, is on tenterhooks. Last week, the state closed its case after calling its final witness. The acting judge in the matter dismissed several pieces of evidence which were copies of original documents the state had not sourced. The judge ruled out most of these exhibits as oral evidence had not helped the state prove their veracity. At the same time, 5 of these 6 criminally charged persons want to be removed from this case and cleared. Let's explore this with William Booth. He's a criminal law expert. Thank you very much, William, for your time this afternoon. When you consider that the Zondo Commission cost almost R1 billion, this does not suggest that it's a good start to actually holding those who are found wanting to account, with the acting judge last week questioning the central theme offered by the state about the originals of the disputed documents being lost. Your thought?
Yes, I think one mustn't prejudge the matter because there hasn't yet been a ruling by the judge in the case. As I understand, the prosecutors seem to be fairly confident. On the other side, the defense have indicated because of the fact that these documents have not been submitted as evidence in the case, that's a factor that will go a long way to assist them in applying for the discharge of their clients. So, yes, one would certainly have liked there to be a much clearer picture as to how strong the evidence is because correctly pointed out, the Zondo inquiry has led to a great amount of money being spent, lots of witnesses being called, a lot of evidence being presented. So one would certainly have liked to see the first case being successful, but we're not quite there yet. But I think it is an issue, it is a negative issue for the state, that the documentation that they've tried to enter, the various emails, are now not part of the case and have been ruled, in effect, inadmissible evidence. So that can't be considered in the judge's eventual ruling. But, obviously there is other evidence as well. But is that strong enough? So at the end of the state case, the test is there evidence on which a reasonable person acting carefully will convict? Not beyond a reasonable doubt, which is the test at the end of the case. So if the state's case is weak, an accused person can apply for his or her discharge, and if that discharge is granted, and whatever is said about the strength of the evidence is then public knowledge, then we will know exactly where we are with regard to other matters going ahead. But even if there's an acquittal in this case, that doesn't mean to say that is the end of the road for each and every other matter that has been dealt with during the Zondo Commission, or the end of the road relating to any extradition application against the Guptas. Because they're not just involved in this one instance, but they're obviously, they've spread their net widely into a number of other state capture matters.
Fair enough. We'll get into the extradition application in a few moments, but we must admit that this rather does set the tone, because the acting judge noted that having carefully considered the evidence tendered so far, she's not satisfied that the originals of the documents are either lost or that a diligent search was conducted. Nothing in the evidence presented by the state suggests that a bona fide and or thorough search for these documents was conducted. Again, this setting the tone, it surely is worrying, though.
Yes, no, absolutely. I mean, your very first case should be, I feel, your strongest case to set the tone. So now, one doesn't know where they are, where are the originals. So it goes to the whole admissibility. When you deal with admissibility of documents, there's a great deal of criteria that has to be followed. Because documents can be manipulated. They can be interfered with. We know that. So that's why the originality aspect is very important. And, comments made about, well, was a diligent search done to obtain the originals? Why was this evidence presented? Of course, I agree wholeheartedly. It is worrying. But, that's not necessarily, whatever the outcome here in this particular case, doesn't mean that's the end of the road for any other prosecution flowing out of the state capture inquiry or any other prosecution that the state wishes to bring against the Guptas.
Let's get more into that, because most of the accused in this case, for instance, are confident that they will be discharged. What then does it mean for the extradition?
Well, again, it's not, this is one instance, as I see it, where the Guptas are allegedly involved. So, there's other evidence linking them to other matters. So the state have got to say, if they lose this case and the judge says, well, there isn't sufficient evidence, that's against the accused. They may be able to come and use, with difficulty, if there's an acquittal of the other accused, they may try to use evidence linking the Guptas. But then again, you come back to the same documents, the same problems that the state faced in this particular case would be relevant to any prosecution against the Guptas. But that's relating to this whole investment issue, not necessarily to other cases, unless, of course, the documents in this case are directly relevant to other cases. And the state might say, oh, well, this judge has ruled that inadmissible. Another judge might come to a different ruling. I don't know what they're going to do. But it is certainly a problem. If the evidence presented here plays a large role in other alleged instances involving the Gupta brothers, and this evidence is determined not to be sufficient for a criminal prosecution in this case, it is a problem. But again, I don't know all the evidence, and I don't think you do, of all the evidence that there is in the various dockets that may link the Guptas, all the evidence that they've gathered to bring in respect to the application for extradition. What is worrying with the extradition is it is taking in an inordinate period of time to be concluded. And, there doesn't seem to be much feedback from the NPA as to exactly where they are. Were they waiting for this case? Are they waiting for other people to be prosecuted? What is exactly the status? And I think the public in South Africa needs to know, what is the status of the Gupta extradition at the moment? And there seems to be a little bit lacking in news about exactly where we stand with that.
How should we then understand this? The Gupta leaks hard drive evidence coming up with the state prosecutor insisting there would be a trial within a trial and having them admitted in the criminal trial proceedings.
Well, a criminal trial has various components. So a trial within a trial can be dealt with in terms of admissibility of evidence. So, for example, the simple statement, was it a confession made to a police officer by an accused person? So, there are various criteria as to the admissibility of a confession, as there are with regard to admissibility of documentary evidence, of emails, of recordings. All of that kind of evidence has to follow certain criteria. The originality is important. Has it been contaminated? Has it been interfered with? Has it been determined that it is in fact correct evidence that can be presented to court? So trial within a trial deals with the admissibility of evidence, and if that evidence is dismissed, doesn't always mean the end of the state's case. In a particular case, they might have other evidence. So, for example, you might have other documents, or you might have direct evidence of a witness, eyewitness to something, who can say, well, the Guptas did this or that, or the accused in this particular matter did this or that, and try and link them to the charges. But obviously very, very relevant in this case are all those documents to try and prove the guilt of the accused. And if that goes out, then it is a significant problem.
So it may not mean the end of the case, William, but does it mean that the charges against the Guptas are no longer strong, or are not that strong, at least where perceptions are concerned?
Well, I don't think one must necessarily deal with perceptions. You've got to deal with evidence. What is the evidence? So if this evidence is dismissed, as I said, another court might look at that evidence, if they're dealing with the Guptas matter, in a different way, because now they're using that evidence against the Guptas, and there may be other evidence as well linking the Guptas. So it doesn't mean if this one court finds this evidence is not allowed to be entered into the court record and used against these accused, that's the end of the road with regard to any Gupta cases. The state have got a whole lot of other evidence, I understand. So is that evidence strong enough? Or if this evidence goes out and they're faced with the same challenge when they try to prosecute the Guptas, then the state has got to decide, well, do we really have enough evidence to continue with the prosecution against the Guptas? And they may turn around and say, yes, they do that. And, but what's concerning, we don't really know exactly all the evidence, because there hasn't been a trial yet against the Guptas, but the strength of the case has to be submitted during the extradition proceedings. So all of this evidence would in my view, surely be used. Sorry, we seem to have had a bit of a break in the link.
Please finish your thoughts.
Apologies from my side for that.
No worries.
So this is also evidence they probably want to use in the case. So if the evidence has been dismissed in one case, it could affect the decision by the prosecutors with regard to the extradition. But again, there may very well, and I'm sure there is, other evidence that they can use to rely on in their extradition. But how strong a case is important. No country is going to extradite somebody to another country if there's a problem with the strength of the case against that person.
Absolutely. But I was reading an article, and the author of the article suggested that if he was the Guptas, he would advise the Guptas to actually come to South Africa in light of some of this evidence being dismissed, and this would be a done deal, really, for them to come here because it suggests that the case is not that strong. Is it that simple?
Well, that is one view, and sometimes, people advise that come to the country because the evidence is weak, and we've got the evidence, and they're not going to prove your case. So come and stand your trial, and don't have to go through a whole extradition proceeding. The only problem is if they do that, then there must be an agreement from certainly their side in place for them to get bail. So, I mean, if I were them, I would instruct my lawyers, yes, we want to come to South Africa, but please make a deal with the NPA that they'll agree to bail, and then be outside and let's run the case. So, that deal can be made, but the state might say, well, we're not interested, you've got to stay in custody. They might say, well, we don't want to stay in custody any longer, we've been inside for quite a while, and therefore we're not going to come, we'll take our chance, in the extradition proceedings. But that certainly is a view, and I think that's a view that needs to be put across to any lawyer's clients with regard to extradition proceedings.
Criminal law expert William Booth. Thank you very much, William, for your time this afternoon.
Pleasure. Thank you.